looking to see about building on the planet Mars. Talking about development, court urges to revisit a MTOTSA case, the MTOTSA case. State Public Advocate Ronald Chen on Thursday filed his amicus brief with the court. It is a friend of the court brief in a Long Branch eminent domain case in which he urges the appellate court to give homeowners their day in court denied by Superior Court Judge Lawrence M. Lawson. Lawson sits in Freehold. When Lawson in June issued his decision upholding the city's right to take Ocean View homes by eminent domain, the assignment court judge sitting in Freehold found no reason to give property owners the right to an evidentiary hearing, relying instead on oral arguments and exhibits. But Chen, who announced his intention to become involved in the case last fall, said the trial court record may be incomplete because of Lawson's failure to allow additional hearings where testimony would be given. It appears that the process leading to the condemnation of appellants' homes lacked that requisite constitutional protections, Chen's brief said. The record contains no evidence that the city of Long Branch notified appellants that their homes might be condemned. The record does, however, include information disseminated by the city that might have led appellants to believe their homes would not be condemned, the brief said. City Attorney James G. Aaron, while expressing surprise that the advocate would release his brief to the media before providing it to the opposing counsel, said Chen's points are ill-informed because the advocate's review of Long Branch case is one-sided. Chen did not visit with city officials to review the process by which they conducted the redevelopment before he formed his opinion on the case, aided only by visits with the affected property owners, Aaron said. Well, guess what? I'm a layman, but Mr. Aaron, he's an advocate for the adverse side. When I'm suing someone, my lawyer doesn't go visit the opposition. He visits the client. I don't know about you fellas. What's going on here? Your spin is getting pretty deep. The Lawson opinion was very strong and bulletproof, Aaron believes, and that the judge covered every issue, except the issue that the people in MTOTSA and Lower Broadway were misled to believe that their buildings would get to remain. Aha! The actual point and issue. Up an entire review of the process and found there was absolutely no reason to hold a plenary hearing on any of the issues that were raised below and now commented on by the public advocate, James said. It is typical of the public advocate, we feel. The public advocate is giving his opinion on things he has not really investigated, Aaron continued. He has not come into the city. That's not true. He has. I've seen him here. He said staff. Yes, he did, but he came himself. He was here. There's a photograph of him standing in MTOTSA in the newspaper. Jimmy Aaron, shame on you. He sent staff into the city predisposed to what he would do. Well, guess what? I attended a meeting on this before he decided to take it on and presented him with as many documents the city would allow the public to have. He was fully briefed to support his legislation rather than focus on what was done by the city and approved by the court. Further, Aaron said, the city notified property owners on a half-dozen occasions, whether it was a notice that their property was being considered an area in need of redevelopment or resolutions, ordinances, and public hearings, all connected to the redevelopment of Beachfront North, where luxury condominiums are planned. Chen also attacked the way in which the city determined the Marine Terrace, Ocean Terrace, Seaview Avenue area, or MTOTSA, was found to be in need of redevelopment or blighted, calling the city's review superficial and cursory. These condemnation cases against the owners of small seaside houses in Long Branch raise serious issues about the fairness, thoroughness, and legality of the process by which longtime residents may lose their homes to private development. Chen said in a prepared statement, the homeowners contesting the condemnation are asking for full discovery and a hearing, and we are urging the court to grant their request, Chen said. Chen's brief also argues that Lawson was wrong when he failed to gather information about the MTOTSA charge that 3 city council members either worked for or held shares in Monmouth Community Bank, which financed part of the redevelopment. A conflict of interest, if established, would invalidate the proceedings that led to the condemnations, Chen said. But Aaron, one of the founders of that bank and city attorney, rejected that charge. Well, what would you expect Aaron to do? The conflict issue doesn't even come into play, Aaron said. It is a red herring with the bank because no document ever compelled, requested, or wanted the developer to seek financing at any particular institution. Well, yeah, like Lynch sent documents out showing things that his letter with the Senate letterhead. Of course, a smart man doesn't make mistakes like that, Mr. Aaron. Secondarily, as to ownership of stock in a public bank, no shareholder in the bank owned enough stock to even create the appearance of a conflict. One share is a conflict, Mr. Aaron. I don't care what ordinances you stimulated the Long Branch Council to pass to protect themselves. The developers were free to seek financing wherever they sought. Yeah, try and go against the financial institution that Council President Giordano at the time was the vice president at, and see if you would get his approval on your plan. Just try it, Mr. Aaron. The developers were free to seek financing wherever they sought, and the developers borrowed a very small percentage for the deal on a short-term basis from Monmouth Community Bank, and it repaid it immediately, even before it was due. Well, guess what? That amount makes the bank look good. Mayor Adam Schneider, whose criticism of Chen has been even more harsh than Aaron's, said it is key that when the mayor asked the advocate whether he had even read Lawson's opinion, Chen said he couldn't remember. If he had, he would have gotten well-informed reasons for ruling in the city's favor, the mayor said. What is clear to me is he and his office made a conscious decision not to talk to us prior to getting involved in this case. And the only reason they talked to us was that they were embarrassed when I confronted him on that issue, Schneider said. We followed the rules, the laws as they continue to exist, Schneider said. We've been open about everything we've done for the last 15 years. I dispute that remark is invalid. It is what Judge Lawson found, and it is what the appellate division is going to find. I appreciate your optimism, Adam. However, you're wrong. You deceived your people. You've got away with it, but you're not going to get away with it much longer. As for your assertions that Chen has not done a thorough job, first of all, Mr. Chen has got a staff of people. Mr. Chen has people looking into the issue. There are other lawyers that signed off on the Americus Brief. You expect Mr. Chen to do everything? And secondly, how do we know you're telling us the truth, Mr. Schneider, when we know you have lied to us in the past? As a matter of fact, I got a resolution where you were cited for lying back in the mid-90s. I don't think you'll find a document that discredits Public Advocate Chen or any of the MTOTSA residents. This is Kevin Brown. I'll be back after this short break. Don't go away.